We're here to talk about patents and collaborative development this morning, and I would start by saying that we've had a terrific run with innovation in the last decade that has been propelled by these collaborative and yet market-driven approaches to sharing intellectual property. Of course, one example, great example, is the efforts made to adopt innovation-driven standards across various industries, and that involves a process that incorporates the best intellectual property, or IP, in any particular field into a standard, ensuring that what's called the patents involved, or standard essential patents, we frequently refer to them as, are then licensed to adopters of the standard on what's called fair and reasonable, or commonly known as FRAND terms. And of course, standards deployed innovation has resulted in many groundbreaking developments in technology in many fields, from autonomous vehicles to telecommunications and on and on and on. It has been, to paraphrase a fable with some resonance here in Great Britain, truly the goose laying the golden eggs. On the other hand, there's another super successful approach to open collaboration, and that is through, of course, open source software. And open source, of course, has an approach to IP that gives developers access to the code of computer programs, of course, developed by others who are working on a given open source project, and enables a developer to form a community of developers and a community of users to share tools and build on common infrastructure. Companies that, of course, use and manage open source projects have succeeded in significantly reducing software development and maintenance costs, and they've provided customers with highly innovative and stable and low-cost software. And of course, open source driven innovation has been critical in many areas in its own right, including cloud computing and big data and mobile technology, to name just a few. Now, the issue is that as hardware and software converge in more and more products, open source software has found itself increasingly included in technology adopted in standards governed by FRAND licensing commitments. So these two historically independently successful worlds have started coming together, and they're encountering some growing pains, as happens when worlds come together that way. So as many in this audience, I'm sure, are aware, there's been an ongoing debate over open source licenses and their integration with FRAND licensing and FRAND licensing commitments that govern licensing of patents covering standards. One part of the debate believes that most open source software licenses are compatible with FRAND licensing of related patents, and the other side has the belief that they are incompatible, right? Or to put it in an economic frame, one side argues that innovators should not be permitted to charge licensing fees for patents associated with software used in standards, and the other side argues that innovators remain free to both contribute their open source software to standards and charge licensing fees or royalties for their patents. So that's the nature of the debate that we're dealing with at the moment. So we then went out and tested some assertions in this regard, and you can see them here. Is FRAND licensing a detriment to innovation? Do open source licenses inherently, or are they inherently incompatible with FRAND licensing? And is the open source definition, the OSD compliant license definition. Does it always contain, or has it always contained, a patent grant? And we'll come back to that in just a moment. I would start, though, by saying a lot has already been said, to kind of back up and level up for a moment. A lot's already been said over the years about the first of the 2 points that I just mentioned. So I'm not going to spend a lot of time on them, but I'll touch on them just briefly. So we can easily see that FRAND licensing isn't inherently detrimental to innovation, setting aside open source for the moment. Industries like telecommunications have, among others, have for decades used FRAND licensing, employed it, and been incredibly successful. They've thrived. There's no data that shows that there's been any detriment from FRAND licensing. And in fact, to the contrary, it's hard to imagine how those industries could have achieved the level of success that they have, given the enormous investments that are required, if the innovators had been told they'd have no way to recoup their R&D expenses. Now, there's also nothing inherently incompatible about open source licenses and FRAND, just looking on the face of them. Now, to be sure, there are some open source licenses, like the GPL version 3, that expressly contain patent grants in them, and that therefore on their face are incompatible with FRAND licensing. But that is definitely the exception and not the rule, with most other licenses having no express language about patents in them at all. And so those other licenses are what we call permissive licenses, and they account, it turns out, for the large majority of OSI's approved licenses, and they don't contain restrictions, and on their face, they are compatible with open source. So what I'd like to do now is to turn from there to what you see here, which is a more in-depth discussion on issues that have not been so much discussed in the past. And to give you a bit of background to start off with, if you're not familiar with this long history, it's been about 20 years or so since OSI, the Open Source Initiative, was formed and began serving as an arbiter of acceptable open source licenses by maintaining this so-called OSD, or the open source definition, which has to be satisfied in order for a license to be considered open source. Now, the OSD sections cover various things, including distribution and derived works and source code and non-discrimination and other aspects. Of particular note is OSD Section 1 and OSD Section 7, which impose requirements for free redistribution. Now, those who believe that patent royalties run afoul of the OSD typically cite these sections as a source of conflict with the OSD licenses allowing for patent royalties. Now, however, when you look at these sections and look at the definitions that are associated with them, neither the OSD 1 definition, which you can see now, nor the OSD 7 definition state that an OSD compliant license conveys a patent grant. They don't refer to on their face, they don't cover patents. However, folks have suggested that even without any express language, OSD compliant licenses come with an implied patent grant that sets up an inherent conflict between OSD 1 or OSD 7, and that this view was the view of the open source community all along. And so what I set out to do was to look at those points in some detail. And to remind ourselves of the conversations, to remind myself of the conversations surrounding OSD compliance and free redistribution attendant to open source software. I took a look at all of the OSI license, discuss, and license review archives that are available, and they go back to April 1999, and looked at them all the way through June of 2018, before writing up this work, looking for discussions mentioning OSD1 or OSD7. And what I found was that the community primarily discussed OSD1 or OSD7 in the context of analyzing whether specific licenses were OSD compliant, and there wasn't really much reference of patents in those two threads of discussion. There were roughly 300 posts that specifically mentioned OSD1 or OSD7 out of a much larger total number of posts. And those 300 or so posts mention licensing issues in OSD1 or OSD7. That's about 4%. Or sorry, that's 300 out of 1,000, so that's a small number. And of those, about 4%, about a dozen or so, had the view that OSD1 or OSD7 require patent licensing. And so, to be fair, there were views expressed through, peppered in those 4% or so, about a dozen posts. The problem is that in each case, those views were contemporaneously challenged by people on the other side of the debate saying, no, I don't agree, there aren't licenses being granted here. The issue resurfaces every now and then, last occurring in 2017. And so what you did not see, what I didn't see, was any evidence of a conclusion or a consensus being reached. And if anything, what the data suggested was the opposite conclusion, that the issue of patent grants and open source licenses was not assumed or overlooked. It actually was raised. As I've mentioned, it's been raised from time to time. It was rebutted, and then it was discarded. And indeed, it's still raised every once in a while, and it doesn't get traction with the community. So I think the only thing you can conclude from what's happened is that at best no consensus has been reached.
Dave, can I ask you a question?
Sure.
As a non-legal community, have you also investigated, I know most of it works under Trademark rules, but a lot of the discussion around patents is amongst the legal groups, where you might not be able to identify an individual statement, but you could certainly look at the discussions that the lawyers were having, or even look at the conferences that have been held over the last 5 to 10 years for the legal communities and open source. A fair number of lawyers,
Right, yeah, I agree with that.
Picture, is it? It's just one of the...
Well, so those are the two parts, the two threads that contain discussion about licensing. There are lots of other threads that, to my knowledge, don't tend to contain licensing discussion. And I agree with the comment that many of the commenters on those threads are actually lawyers. So I went and next examined the case law to see if there's any legal basis for the view that an OSD compliant license grants an implied patent license. And started with a case that's actually cited quite a bit in the community, and I think well-meaning. It's the TransCore versus electronic transactions case, and it was a U.S. case. I'm going to look at U.S. law. Being a U.S. lawyer, I should comment that some of the doctrines involved here, as I understand them, are actually construed much more narrowly here in the U.K. So, whatever conclusion a U.S. lawyer might reach, my understanding, you can get a U.K. lawyer to comment on this more definitively, is that a U.K. lawyer would reach an even more narrow conclusion. So the issue with this TransCore case is that it takes up it takes up implied licenses in a very different context than what we're talking about. TransCore's implied license was dependent on a specific set of facts in that case, which involved an earlier express patent grant on patents and a litigation on patents covering technology, and then a covenant not to sue that was given in the context of a settlement of that earlier patent litigation. So there was patent litigation, there was a settlement, there was a covenant not to sue, which means an express grant relative to patents, and the TransCore court then found that the covenant not to sue on a patent that existed at the time the covenant was granted created an implied license to a later issued related patent. So an interesting decision, but completely irrelevant to the open source context. In that decision, however, it is interesting to note that the Federal Circuit, quoting its prior opinion in a case called Wang Laboratories, stated, quote, legal estoppel refers to a narrow category of conduct encompassing scenarios where a patentee has licensed or assigned a right, receiving consideration, and then sought to derogate from the right granted. And so there's this language used in that decision that keys on narrow category of conduct, and that's the way the implied licensing cases tend to work in the U.S. TransCore clearly involved patent rights affirmatively granted by a patentee to begin with, and so unlike the OSD license context, it's not a situation where there's no affirmative right and you're trying to figure out whether to imply one. So the OSD context just doesn't lend itself to this case or to this thinking of the so-called narrow category of conduct. Now, in Wang Laboratories, if you go back to that case, which the Federal Circuit was relying on, it also found an implied license, but its finding was rooted in a different area of law, equitable rather than legal estoppel. So the plot kind of thickens in a different direction in the Wang case. And the reason that's important is because legal estoppel, which was the subject of the TransCore case, looks at this so-called affirmative grant of consent or permission to make, use, or sell, i.e. looks for a license. But equitable estoppel looks in a different direction. It's focusing on misleading conduct that suggests that the patentee won't enforce its patent rights. So equitable estoppel, a doctrine that's looking for misleading conduct, is even less of a basis to imply a license in the OSD context, because there's not any suggestion at all of any misleading conduct. So you can't get there either by way of legal estoppel or by equitable estoppel. I wasn't able to, when reading other cases, I wasn't able to find any court case that holds that patent licenses are implied in open source licenses in the absence of patent granting language specifically. Now, some have pointed to another case. It's called Simpleware, X-I-M-P-L-E-ware versus Versata. And that's a case where Simpleware software was licensed under the GPL2 license agreement. So this sounds pretty interesting, right? Because the GPL2, it's got some language that's pertinent. It's clearly a copyleft agreement. Some might say that it expressly or impliedly makes a patent grant, and I think that's actually a pretty darn good argument in the case of GPL2, although I don't know that it's completely settled. But the problem with that case is that Simpleware sued Versata and its customers for patent infringement when its source code was discovered in Versata's products, and the court treated the GPL2 as a defense to patent infringement. So it said, we think that the GPL2 granted a patent license. Fair enough. Since the GPL2 does contain patent-related language, and everyone knows Section 7, one of our favorite sections to all lawyers in GPL2, it doesn't grant an express patent license, but again, you could reasonably imply a patent license, as the court did in that case. The GPL2 is an example, it's a situation of an example that, or an exception that proves the rule. The GPL2 is the kind of license that you might consider using if you want to be able to say that you're providing patent grant. If you really want to be sure you're providing a patent grant, use the GPL3 because it expressly does. My point, though, is that the simpleware case simply can't be applied to licensing situations where the license is completely silent on patents, which is most of the OSD compliant licenses and the ones that are interesting for purposes of this discussion. So it's a fine case, but it stands for the it in fact stands most clearly for the proposition that the licenses that don't say anything about patent grants can't be implied to include patent grants. You've got to have a license that at least says something like the GPL version 2 did. Court made a good decision in that case. So, in fact, the general case law surrounding implied licenses, again, it indicates that if anything, courts are very hesitant to imply a license where one is not expressly granted. The courts have discussed judicially implied licenses, and they use words like rare. In the cases that I read, you see those kinds of words. Or found only in the most narrow of circumstances where one party created a work at the other party's request and handed it over, intending the other to copy and distribute it. And that's a quote from a case that found an implied license. So it's the really clear situations where a license will be implied. But some people have argued that the distinction between contributing to open source versus distributing open source would be an important factor in any judicial analysis of whether an implied license exists. So that's to say that the thinking is if you voluntarily contribute code under a license with a disputed scope, as opposed to simply redistributing code that others have created, that you would be more likely to have an implied license. I don't know about that. The problem with that logic is that in the end, whether you've granted a license or not depends on the language of the underlying license and the law that we've just been talking about. And it doesn't make a distinction between code you created and distribute versus code that you just redistribute. So I couldn't find any basis to draw that distinction. In fact, it can just as easily be argued that that a party that's only contributing code under the assumption that they're not relinquishing any patent rights, it isn't relinquishing any patent rights any more than the party that redistributes code that they didn't write under the presumption that they're not divesting any patent rights. So I wasn't able to construct an argument that distributing your own code makes any difference in this regard. So I looked at another question too, which is, we've got, these really famous benchmark licenses that have been around a long time. Why not just ask the folks who own, if you will, or created and are the namesakes of these licenses what they meant and how they interpret them? And so I did that and contacted both the folks at Berkeley in their tech transfer office, which is where the BSD is owned, if you will, and the folks at MIT. And so they also said that, probably not surprisingly, that they do not consider their licenses to convey patent grants of any kind. The Berkeley Office of Tech Transfer recommends the BSD to their community members, they said specifically because there are minimal restrictions and maximum compatibility with other software and licenses. And in the case of MIT, their guy in charge of their license, who's Dan Dardini, noted interpreting OSD compliant licenses, in his view, to include implied patent grants would create a huge potential conflict with MIT's portfolio of patented technology. So in both cases, the tech transfer offices said, no, we didn't and don't intend that our licenses convey any patent rights. Going back to the comments that people make about their intent with these licenses, I mean, you folks could go, Dan Dardini, I'm sure would be happy to answer emails or get on the phone with anyone, as would the folks at Berkeley. What they were conveying to me was their recollection and their intent from the very beginning, not just how we reinterpret our agreement now, but they were saying, look, we never, from the beginning, we never meant these licenses. And to the point about courts having their own view, yeah, sure, courts have their own view, but courts' views are based on evidence. And evidence is, what people wrote, we've talked about that, what people said contemporaneously with events, that's the OSD1 and OSD7 files that I went back and looked at, and what people who are knowledgeable, the purveyors of these agreements, said and say. And so I would say that while courts will make their decisions, all of this information would be quite probative to, how these agreements were and now should be interpreted. So we got a couple of other questions, man, or comments?
Well, I think it's also equally interesting to look at the policies that MIT and Berkeley have for open source usage within their own universities. Because if you look at the policies that they publish, they tell their professors and students and the various companies that they spin off that they can use the MIT and BSD with their accepted licenses. And in those policies where they say that you can use these licenses, there isn't an asterisk that says, but first you must come to our office to make sure that we buy a patent license for these things, right? So when they're looking at what they're using, that's not the assumption that they're making.
Oh, sure it is. And these guys were very clear to point out that the reason they encourage their scientists to use these licenses is because there's no patent grants involved. What they're concerned about at places like Berkeley and MIT isn't incoming patent grants. Nobody sues universities for patent infringement because universities don't make anything. They're concerned about licensing their patents outbound, right? And so their whole concern is they don't want to be granting patent rights because they want their patents to be useful to recover royalties, to be able to fund more research. So this brings us back, actually, in concluding, to the bigger picture, which is that OSD compliant licenses can't really be viewed in isolation. They're part of a larger ecosystem. The software they cover is now integrated into very sophisticated products like the smartphones that we all have in our pockets right now that encompass lots of IP involving lots of functions and lots of components. And given the level of integration of open source software into such widely varying products containing innovations well beyond the software, an implied patent license to the software inherently extends to those further innovations. This, in turn, creates an unavoidable consequence of open source software then undermining patent rights well beyond the software itself, if it was interpreted as conveying these broad implied licenses. And that would be an extreme result. I don't think anybody would have said they intended that that distributing open source software would grant a license to, an entire large product, including lots and lots of hardware and other functions. And then, trying to imply a patent grant from an OSD compliant license really is trying to solve a problem that's already addressed by existing safeguards. And what I mean by that is that the measure isn't necessary to protect technology implementers from unfair royalties. In fact, the FRAND system of licensing, which requires standard development organizations and their adherents to take licenses and grant them on reasonable terms, already constrains the behavior of all parties involved, and has been enormously successful in doing that. And of course, as I mentioned before, open source authors who want to extend a patent license always have the ability to do that and can simply do it by using the GPL3, which has an express patent grant in it. And so I'll end it there and just say that you know, by way of a sort of a final summary, so we looked at these conflicting positions about OSD licenses. We examined the facts and the law behind them. We didn't find significant support for the notion that OSD compliant licenses convey patent rights. Not in the case law. It's not in any community consensus. So in short, what we found was an OSD licensor can choose to grant a patent license, or like MIT and Berkeley, can choose not to do so and preserve the ability for OSS, open source, and SEPs to work in tandem in advancing integration, advancing innovation. And I would say that integrating, thinking about open source licenses and FRAND licensing in that kind of integrated way fits really well into the European Commission's own conclusions in this regard, which is that it creates a win-win situation. I'll stop there. We're out of time, so we can have a side discussion if people want to free up the room for the next meeting. Okay, thank you.